Good evening, everyone. This is Rukhsat Meem. Today, we will be exploring a crucial aspect of business expansion, focusing on the key legal considerations in Singapore. Our topic for today's presentation is expanding operations, key legal considerations in Singapore. Singapore, well known for its vibrant economy and business friendly environment, has become an attractive destination for companies seeking to expand their operations. However, it is important to note that venturing into a new market requires a comprehensive understanding of the local legal framework. On this journey of expansion, it is crucial for Canadian firms to be aware of the legal landscape in Singapore and ensure compliance with relevant laws and regulations. By doing so, business can mitigate risk, foster successful growth, and tap into vast opportunities that Singapore has to offer. So, let's dive into the key legal considerations that Canadian firms should bear in mind before embarking on their expansion in Singapore. We will explore two important laws that hold significant relevance for business operating in this dynamic market. But before we delve into the specifics, let's understand why it is essential to familiarize ourselves with local laws before expanding operations in Singapore. All the countries in the world, why Singapore? Because Singapore offers compelling reasons for Canadian firms to expand their operations due to two key aspects: the Personal Data Protection Act, also known as PDPA, and the Environment Act. The PDPA ensures strict regulations for handling personal data, emphasizing responsible data management and providing individuals with control over their information. This framework establishes trust and compliance, benefiting business and customers. Additionally, Singapore's Employment Act covers various employment aspects such as working hours, leave entitlements, and termination benefits, ensuring fair treatment and a conducive working environment. Canadian firms can expect a well regulated employment landscape that prioritizes employee welfare. Overall, Singapore's commitment to data protection and employee friendly policies makes it an attractive destination for expansion. Now that we understand why Singapore is an excellent choice, let's move on to the next slide to delve deeper into the Personal Data Protection Act and Employment Act. Now, I would like to discuss the Personal Data Protection Act (PDPA) in Singapore. The PDPA is crucial legislation that regulates the collection, use, or disclosure of personal data by organizations. Now, let's briefly go through the key points. The PDPA is based on several key principles. First, organizations must obtain individuals' consent before collecting, using, or disclosing their personal data. Consent should be clear, informed, and voluntary. Second, personal data should be collected, used, or disclosed only for specific purposes that individuals are aware of and have consented to. Next, organizations are responsible for ensuring that personal data collected to accurate and up to date. Reasonable steps should be taken to correct or delete inaccurate data. Additionally, organizations must protect personal data against unauthorized access, disclosure, or loss by implementing appropriate security measures. Individuals have the right to request access to their personal data and request corrections if necessary. Organizations must respond to such requests within a reasonable time frame. Moving on, organizations must appoint a data protection officer who will be responsible for ensuring compliance with the PDPA. In the event of a data breach, organizations are required to notify affected individuals and the Personal Data Protection Commission. Failure to comply with the PDPA can result in fines, imprisonment, or both, depending on the severity of the violation. Moving forward, we will explore the benefits of PDPA compliance, which stands for the Personal Data Protection Act. Let's discuss the four key benefits of PDPA compliance mentioned in this slide. The first benefit is enhanced data protection. PDPA compliance means that organizations have implemented strong measures to protect personal data. This includes safeguards against unauthorized access, breaches, or misuse of sensitive information. By prioritizing data protection, organizations build trust among customers, partners, and stakeholders. The second benefit is legal or regulatory compliance. PDPA compliance ensures organizations meet their legal obligation regarding data protection. Non-compliance can result in penalties, fines, or other legal consequences. By adhering to PDPA guidelines, organizations demonstrate their commitment to protecting individuals' privacy rights and comply with data protection laws and regulations. The third benefit is improved customer confidence. PDPA compliance reassures customers that their personal data is handled with care, respect, and transparency. Customers are more likely to choose business that prioritize their privacy and data security. The fourth benefit is a positive business reputation and competitive advantage. PDPA compliance positively impacts an organization's reputation, positioning, and as a responsible and trustworthy entity. Demonstrating a commitment to data privacy sets a business apart from competitors. Moreover, complying with PDPA may open up new business opportunities. Now, let's talk about the Employment Act, the law which serves as the primary labor legislation in Singapore, ensuring that employees are granted basic terms and conditions of employment. It plays a vital role in safeguarding the rights and interests of workers across various industries. The Act coverage extends to most employees in Singapore, with a few exceptions such as seafarers, domestic workers, and public servants. It is applicable to both local and foreign employees, emphasizing the commitment to fair and equitable treatment for all workers within the country. Let's delve into some key provision of the Employment Act. Firstly, it sets a limit on the maximum working hours, allowing employees to work a maximum of 44 hours per week. This provision ensures that employees are not overworked and helps maintain a healthy work life balance. The Act also addresses overtime payment, ensuring that employees are fairly compensated for working beyond their normal working hours. This provision is crucial in recognizing and rewarding the additional effort put in by employees. Another important aspect covered by the Act is annual leave entitlement. After completing 3 months of service, employees are entitled to a minimum of 7 days of paid leave per year. This provision recognizes the importance of rest and recreation of employees to maintain their well-being. Additionally, the Act mandates paid leave on designated public holidays, recognizing the significance of these occasions for employees. Sick leave is also covered, with employees being eligible for paid sick leave after working for at least 3 months, ensuring that they have the necessary support during times of illness. Moreover, the Act addresses maternity leave, offering eligible female employees the right to take maternity leave. The provision acknowledges the importance of supporting employees during the crucial period of childbirth and early parenthood. The Act can also provide guidelines for termination and retrenchment process, outlining fair practices that employers should follow when making employment decisions. This ensures that employees are treated fairly in cases of termination or downsizing. Employers have their own obligations under the Act. They are required to provide itemized pay slips to employees, maintain employment records, ensure workplace safety and health, and comply with minimum employment standards. These obligations emphasize the importance of creating a conducive work environment that prioritizes the well being and rights of the employees. Now, moving forward, let's talk about the benefits of Employment Act compliance in Singapore. The Employment Act provides legal protection to employees, safeguarding their rights and ensuring fair treatment. Compliance with the Act is essential for employers to avoid legal disputes, penalties, and reputational damage. Compliance with the Employment Act promotes fair employment practices such as non discrimination, equal pay, and protection against unfair dismissal. The Employment Act sets limits on working hours to ensure a reasonable work life balance for employees. Compliance with the Act regarding overtime compensation helps prevent employees' exploitation and promotes their overall well being. The Employment Act stipulates minimum level of annual leave and sick leave and maternity leave entitlements for employees. Compliance with these leave provisions enhances work life balance, supports employee well being, and boosts overall morale. Offering adequate leave benefits demonstrates an employer's commitment to supporting their employees' personal and familial needs. The Employment Act provides guidelines for their fair termination and retrenchment processes, ensuring employees are treated respectfully and fairly. Compliance with these guidelines promotes a positive employer-employee relationship and minimizes potential legal issues. When employers handle termination and retrenchment in a fair and a transparent manner, they maintain trust and preserve their reputation as the employer of choice. To conclude, I would like to say that compliance with the Employment Act and PDPA law in Singapore brings about significant advantages for both employers and employees. By adhering to these laws, employers ensure fair treatment, promote work-life balance, and provide legal protection to their workforce. This not only creates a positive work environment but also contributes to building a strong employer brand. Thank you.